Beep, 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 beep. Live from Wellston, Georgia, it's another episode of the Wartown Times. Be sure to stay up to date by joining the Wartown Times Facebook group on the Facebook.
6. The Constitution and a piece of paper walk into the bar. Lawyers are not your friends, literally. While you may have friends who are lawyers and while not operating in the capacity of a member of the Bar Association, they can be quite personable, ethical, and moral. But make no mistake that when beaming with pride and flashing their Bar Association card to agents of the court, said association is where their allegiance truly lies. While most of them tell themselves fairy tales about upholding the law, justice, and the best course of actions for their clients, most of them do not have the capacity to, or are simply unwilling, to appeal to the supreme law of the land to do away with most of the charges they earn a living defending people from. Again, many attorneys fail to utilize the genie lamp of the Bill of Rights because they're ignorant to just how powerful it is or could be in controversies without victims. Yet, many simply will not because in doing so, the preparation, duration, and compensation for them would be significantly reduced. Haven't we all had a coworker or business partner that overinflated the actual workload or stress load they're tasked with to justify the cost of having it done? Of course. The Bar Association is basically a whole lot of people like that who collaborate to collectively build the illusion that the law is really, really complicated and we the people best come a-running to them when we get caught in the web of legality. Is this collaboration some conspiracy that is intentionally executed by lawyers? Probably not. The blatant oversights of utilizing the Bill of Rights and subsequent Supreme Court rulings that reinforce it is done through the usual suspect of villainy, ignorance. The fact of the matter is most lawyers who suck on the teat of the Bar Association are completely unaware of the information you have read thus far in this friendly neighborhood manifesto that could, in most cases, keep their clients out of privately owned, for-profit prison facilities. They simply do not know these things. They were not taught these things in college, and they were not taught these things in law school. They were not shown that the profession they had decided to commit a significant amount of their time, energy, and money to go into is primarily dependent upon the belief that statutes, acts, codes, and ordinances are the law, but not the law. No, rather, they spent a whole lot of money to be taught that the law is specifically statutes, acts, codes, and ordinances. And they have a piece of paper or two from a university or two that came at great personal cost to affirm these illusions. And it is these expensive pieces of paper which bind them to an ego-based stance to outright reject the philosophies presented by our founding fathers, documents, and Supreme Court rulings, which are merely being cited here in this friendly neighborhood manifesto. You see, to a lawyer, or anyone for that matter, to be confronted with the suggestion that they spent a considerable amount of their life learning to perpetuate a farce, well, that can really do a number on the old ego and sense of intelligence, which is understandable, but not excusable. This is why in the event you have ever attempted to have a conversation with a card-carrying member of the Bar Association about the Constitution, their immediate knee-jerk response is to bring you down from the supreme law of the land into where they feel comfortable. That being the hall of smoke and mirrors we know as statutory law. Any point you attempt to make with them utilizing the Constitution and Bill of Rights is dismissed, demeaned, ridiculed, or scoffed at immediately with disdain. Not because you're wrong, but because treading above the surface of their expertise in supreme law kind of diminishes all the accomplishments they're ever so proud of, receive kudos for, and charge hefty fees for avoiding. The same ego-based responses are given in the unfortunate event you must procure a consultation with a member of the Bar Association over a violation of a statute, act, or ordinance. Feel free to call around law firms in Wartown and inquire if they will defend you for cannabis or other plant sacrament charges on a First Amendment basis, and then set a timer to see how fast they begin bringing up OCGA or how the local judge isn't going to be accepting that argument. Never mind their duty to argue them anyway. Bringing up the supreme law of our land, and in turn Wartown, will certainly get you a good talking down to by a member of the Bar Association. You will hear phrases that sound an awful lot like, yeah, that's not how things work. You might want to try living in reality. And by the time they're done, you will be left with the overwhelming impression that the Constitution, Bill of Rights, or Supreme Court don't exist or matter whatsoever. Without knowing the information in this friendly neighborhood manifesto yourself, you are compelled to believe them and depend upon their expertise and legalities, which again comes with considerable amounts of money being transferred from you to them. Again, this is not to say that every lawyer is deliberately doing this to deceive you for retainer fees and additional costs on an ongoing and unnecessary trial, as many of them believe they are charging a fair exchange for their time and services. Of course, this is also not to say that there are not attorneys who will deliberately drag cases out for that very purpose. At the very least, what you, the dear reader, need to understand is that you have a personal responsibility to know your rights, assert your rights, as well as the elements of your own case, should you be involved in one. And procuring an attorney to represent you rather than to counsel you is essentially saying that you're incompetent to represent yourself. It is the default position of those within the Bar Association to sell you on the emotion that you are indeed too incompetent to argue your own case, because that's what they get paid to do for a living. And hey, if that's the route you want to go, then more power to you. Just know that much like walking into a car lot, the salesman is going to be itemizing a lot of charges you do not understand and probably do not need. To get our head around this, let's ask ourselves a few more questions with the information we are assimilating thus far. If an attorney having your previously secured rights in mind were to represent you in the following instances, is not the following thought experiment the easiest and most cost-effective way to proceed against pending charges? Charge: possession of cannabis, psilocybin, San Pedro, ayahuasca, other plant medicines, or sacraments. Response: motion to dismiss with prejudice, as the state arbitrarily wrote a statute, act, code, or ordinance that conflicts with the previously secured rights of the defendant per Marbury v. Madison, Murdoch v. Pennsylvania, Shuttlesworth v. Birmingham, Alabama. Charge: intent to distribute cannabis, psilocybin, San Pedro, ayahuasca, other plant medicines, or sacraments. Response: motion to dismiss with prejudice, as the state arbitrarily wrote a statute, act, code, or ordinance that conflicts with the previously secured rights of the defendant per Marbury v. Madison, Murdoch v. Pennsylvania, Shuttlesworth v. Birmingham, Alabama. Charge: driving without a license. Response: motion to dismiss with prejudice, as the state arbitrarily wrote a statute, act, code, or ordinance that conflicts with the previously secured rights of the defendant per Marbury v. Madison, Murdoch v. Pennsylvania, and Shuttlesworth v. Birmingham, Alabama. Charge: driving without registration. Response: motion to dismiss with prejudice, as the state arbitrarily wrote a statute, act, code, or ordinance that conflicts with the previously secured rights of the defendant per Marbury v. Madison, Murdoch v. Pennsylvania, and Shuttlesworth v. Birmingham, Alabama. Charge: operating a business without a license. Response: motion to dismiss with prejudice, as the state arbitrarily wrote a statute, act, code, or ordinance that conflicts with the previously secured rights of the defendant per Marbury v. Madison, Murdoch v. Pennsylvania, and Shuttlesworth v. Birmingham, Alabama. Charge: violation of public curfew. Response: motion to dismiss with prejudice, as the state arbitrarily wrote a statute, act, code, or ordinance that conflicts with the previously secured rights of the defendant per Marbury v. Madison, Murdoch v. Pennsylvania, and Shuttlesworth v. Birmingham, Alabama. Obviously, this is a very simplified verbiage, but why shouldn't it be that simple? It is, after all, what these and many other frivolous charges can be reduced to. After all, isn't it the primary function of the courts and its officers to safeguard the rights of the American people and the people of Wartown first and foremost? Indeed it is. And if we see and experience a systemic neglect of this duty, we the people must demand a redress of grievance in the long train of abuses by the Bar Association, law enforcement, and the judiciary in their collaboration of apparently utilizing the court systems to violate our rights in the perpetuation of revenue generation in conjunction with scores of unlawful detainments in privately owned, for-profit prison systems in our community. Is this the type of activity Wartown needs from members of the Bar Association practicing law in our community, unable or unwilling to fervently, efficiently, and aggressively defend our rights with the supreme law of the land? Do we want the only recourse from them when defending us to be the descent into inferior statutes, acts, codes, and ordinances, when appealing to the supreme law will get us out of the crosshairs of a system that has all but forgotten what we instituted it for? For those of us who have been abused by it, the answer is obvious. For those who will eventually be caught in it, remember that apathy of tyranny is cooperation with tyranny. This is true if you are a member of the Bar Association or not.
Beep, 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 beep. Live from Wellston, Georgia, it's another episode of the Wartown Times. Be sure to stay up to date by joining the Wartown Times Facebook group on der Facebooken.